Oh, there you go. All right, get my gavel out, make it official. Good morning. I'm going to go ahead and call this informal pre-hearing conference for the City of Gig Harbor hearing examiner to order. For the record, it is March 14th, 2023, and we are here again for an informal procedural conference related to an appeal by Thomas Wick of a determination of non-significance, or DNS, that the City of Gig Harbor issued. I think it was on January 9th of 2023, and that was then later reissued and with a revised comment deadline on the 27th. And specifically, the appeal concerned a proposed non-project action, which involved the adoption of the city's 2023 stormwater management and site development manual. And alleged that the proposed manual would fail to adequately account for potential environmental impacts that may result from its implementation. Essentially, I did issue a pre-hearing order on March 7th of 2023, the intent being to clarify matters and simplify matters for the parties. Unfortunately, it appears to have caused the opposite effect, and specific language in the pre-hearing order, if I can find it. Specific language essentially said something to the effect of the hearing examiner is directed by the city council to hold an appeal. See if I can find the exact language. I apologize. Oh wait, that's why that's my order to have a pre-hearing conference. I'm looking at the wrong document. I don't have it right in front of me, but if I recall correctly, the language was something to the effect of the city council has directed the hearing examiner to hold an open record appeal related to this matter. And the appellant took that to mean that there had been a meeting by the council at some point, and the council then made a vote or did something and told me, the hearing examiner, to set an appeal hearing. That is absolutely not what occurred, and my intent in issuing my order on the pre-hearing conference was to hopefully get some clarification on that. It was just language that was probably a little bit inartfully written, a little too lawyery or flowery, but the language that was referenced simply meant that the municipal code requires me to have or preside over a hearing of this nature. I have had zero involvement with the council. The council has not communicated with me on this matter, let alone any other matter that I'm aware of. So just wanted to make that abundantly clear and answer any potential questions that either the city attorney or the appellant may have in that respect. That said, part of the challenge was, while my pre-hearing order did not call for pleadings of any kind because of timing, ultimately there was sort of dispositive motion by the city attorney to have this matter dismissed, or either the idea that perhaps the appellant wished this matter to be withdrawn. And so perhaps I can hear from Sarah Springer briefly on next steps in your mind that would be appropriate, given that Mr. Wick has elected not to participate and work on clarification. With that, and did I introduce myself? Andrew Reeves? Hopefully I did. The hearing examiner, again, I have been selected by the council to perform this role for Gig Harbor, but not in any way, shape, or form directed specifically in this case to do anything. If they have had any discussion about this manual, I am unaware of it, had no involvement in it, etc. I was simply, again, going off the language in the municipal code and produced, again, a pre-hearing order that unfortunately had language that was created confusion unintentionally. So with that, Sarah Springer, if you could introduce yourself.
Yes, Sarah Springer, I'm counsel representing the city of Gig Harbor in this matter.
Thank you. And so to that end, please clarify if I misstated kind of the process that occurred. I did not ultimately, produce any decisions on any of the motions, and that was somewhat intentional. thinking that timeline and timing wise, based on the back and forth that was occurring, it occurred to me that perhaps using this time for a pre-hearing conference would help and clarify things. But I recognize that there are either a request or an idea that this appeal be withdrawn, either by the appellant, to the extent that the appellant is of the opinion that something happened that should not have happened, and so this is a sort of, I don't know, we should not have a hearing, as it were, and that was my hope, was to clarify that the thing did not occur. But I also know that you, Attorney Springer, had requested this, that I sort of treat that as a request to withdraw the appeal. But I just would like you to speak to that idea briefly, if you could.
Yeah, thank you. I think that the examiner's being a little too humble in throwing your orders under the bus as for lack of clarity. I think that any initial confusion by the appellant that they could have had regarding the process was clarified by city staff and myself in emails exchange. Particularly, there was a very short, succinct direct email that I sent to appellant stating that in no uncertain terms had the city council ever reviewed this matter or discussed this matter, nor would they ever be discussing this matter. So it could not have been more clear, could not have been more simple, could not have been more succinct. And the fact that appellant continues to rehash the same arguments, criticisms, critiques, complaints about the process demonstrates that there have been multiple times where he could have gained some clarity on the proceeding, and he hasn't demonstrated that he's willing to or able to appreciate that clarity and to understand the process. So in that regard, the first few times that appellant asked for a return of funds and claiming that a hearing had happened without his presence, wanting to ensure that the city didn't trample on any of his due process rights, if you will, for his appeal. We didn't act on those and intended to maintain the pre-hearing timeline as it was in the original pre-hearing order. Now, this has been his fourth request, I would count. I could be wrong in that count.
Attorney Springer, I'm going to stop you momentarily, to the extent that in terms of what happens with the money tends to be beyond the scope of my involvement, as far as I'm aware, meaning I don't believe the code tells me whether or not I should be directing funds being returned. If it says otherwise, I'm happy to address that. But in terms of when I don't need to get into the money, I prefer not to. But my thinking was, next steps in terms of, do I just treat this as the appellant requested to withdraw, or I am granting an order that you have requested to dismiss? Sorry, am I granting a motion that you have requested to dismiss? I guess there is a difference between a withdrawal and a dismissal. Could you just maybe speak to that issue and if I'm wrong about the money, I apologize. I just, I do try to avoid, when possible, that's, the funds in these instances.
Yeah, no, absolutely. And I do believe that it is in the rules of procedure that states that the appellant fee is non-refundable. I was just looking for that here because I thought I had that in front of me, but we can provide you with that. But agreed that, money aside, to the extent that the arguments of appellant of why he thinks this proceeding hasn't happened and or has happened in some cloak of secrecy without his participation. He does use the fact of give me a refund as a de facto way the city believes as saying, I don't want this anymore. Give me my money back. This process is a sham. I don't want to be a part of it. That's essentially what the city is asking for you to determine based upon the numerous emails and communications from the appellant, including that he sent this morning.
Okay, so I understand, I believe, and even in terms of, I know I just said I didn't want to get into money, but I guess the basic fact was that the money at one point related to a PRA request, I have no intention of getting involved with, but at least that seems to be in those emails. But my point, I guess more succinctly, in your mind, Attorney Springer, would it be, what order in your mind should I produce? Should I be producing an order that essentially says the appellant requested withdrawal, it's granted, or am I going to decide your motion to have this matter dismissed?
The
Do you
city,
have a preference? I'm just curious.
yeah, absolutely. The city would like the most efficient and effective way to dispose of this matter. And the most efficient way of doing that would be for Your Honor to issue an order indicating withdrawal of the appellant.
Okay, withdrawal.
Yeah.
All right. Then in some respects,
Essentially accepting the withdrawal.
okay. Then you and the appellant in that respect would sort of be on the same page, and I did not mean to set up any kind of conflict, but were this matter to be appealed further, I think the Superior Court would view the withdrawal versus a motion to dismiss being granted differently, and I just want to make sure that I am not misunderstanding. And generally speaking, an appellant can withdraw in advance of the appeal as a matter of right, and so if the city attorney agrees that that's the way forward, I will accept that and produce an order to that effect sooner rather than later, and that will then be provided. And with that, then no further hearing on this matter need occur. In terms of me, the hearing examiner, I suspect that at some point the council will have this in front of them, and but hopefully when that occurs, it will be in line with the Open Public Meetings Act, which I expect will happen, but I won't be involved, and that will be that. So we do have others that joined. Again, I didn't require that anyone else participate other than the city attorney and our appellants, but I do appreciate others being available just in case. But I think unless anyone has any final thoughts they wanted to provide, I have heard the city attorney's arguments, and I have determined that I will produce an order of withdrawal, and this matter will soon essentially go away, and we'll go from there. Does that make sense to everybody?
Yep, that's great. Thank you very much.
Okay, so with that, I don't intend, by the way, before I close, I don't intend on sort of hashing out every email. I will note that Mr. Wick did send something right before we started, but other than that, my order I expect will be somewhat straightforward, and not longer than my order on the pre-hearing conference, I would expect. So hopefully today's Tuesday, hopefully you guys will all receive that tomorrow, I would hope so. And this matter will move on however it will move on. And with that, I think we can end the hearing. So thank you, everybody. Please enjoy the rest of the day, and thank you for taking the time to participate in the process.
Yep. Thank you so much for your time. I appreciate it.
Thank you.
Thank you.